Did your tests not look like this? Yeah, but you would expect here normal would be non-reactive. That's what I would imagine. Or negative. You wouldn't test positive for having the antibodies for HIV.
Top 5 angry judge moments in court.
Pulse clinic B. HCV, non-reactive.
Oh, shit. Is that something that's not actually what that looks like, or?
HIV negative, syphilis non-reactive, HIV positive.
Well, wait, I don't understand this actually. I don't get this. Anti-HCV bioline, the result was non-reactive. The expectation is for it to be non-reactive. HSV test, negative. Normal is negative. Anti-TP, syphilis, whatever syphilis is, non-reactive, expect to be non-reactive. HIV, AGAB. Why is the normal? Who reads these? It's a teeter. You may have had HIV in the past. Yeah, I think this AGAB stuff is usually, it's a type of like antibody. But if your body is producing, I don't know why you fucking retards keep typing, read the interpretation part, it's not helping. Holy shit, please stop. If you're producing an antibody to something, usually that means that you have an infection. That's my understanding of it. But I don't know why under normal, I don't know why it would say positive. I don't know what that means, I don't understand that. Did your tests not look like this? Yeah, but you would expect here normal would be non-reactive. That's what I would imagine. Or negative. You wouldn't test positive for having the antibodies for HIV. So I don't know why under normal it says positive. Could it be normal positive because it was detected on a previous test? I don't believe so. I think that normal here usually just tells you what the expectation of the test is if you don't have an infection. Non-reactive means that there's, I was about to bullshit, I don't know. They're looking for antibodies. Basically, when your body gets infected by a thing, your body produces antibodies to fight the infection. When you check, this is like a house moment. What looks like an infection, but isn't actually an infection? Oh, it's actually cancer in your fucking fifth boob, hiding under your kneecap, right? When you are testing for diseases, I don't think you normally test for diseases. What happens is when your body's trying to fight a disease, your body makes like a little key lock basically that matches the disease. And then when you're testing a thing, you're testing for the antibodies in your body. And if your body's made a key, it's like imagine you go into a room and somebody's got a vest on that says, you know, like I'm the thief murder force. Well, okay, well, there are probably thieves here, right? That's why we have a thief murder force here. And before some fucking actually retard brings up bacteria, stains, and yes, you can also grow stuff as well, but I think that AGAB test, I think, are looking for antibodies. A positive result in a 4th gen HIV AGAB test means that your test has detected either HIV antibodies, HIV P24 antigen, or both in your blood samples, you're likely with HIV. Sure, I know. I understand that. I just don't know why under normal, I don't know why it says, because normal is usually, I think, your expected reading if you're not infected with something, or it'll give you a reference range for some test. I think normal is just a labeling error. Oh, like they f***ed it up. Wait, did he kill his stream after this? Is that true? Or maybe in Thailand it's just normal to have AIDS. I feel like Wes memes the f out of literally everything. I feel like if he shut his stream off here, it was a meme. Like he edited this document for memes or something. Maybe? I'm a doctor. Normal means that he is within the normal range for these antibodies. If he had HIV, it would be much higher. What? I don't believe you. Your body shouldn't be producing any antibodies if that infection isn't present in your body. Your body doesn't just randomly produce antibodies to things. No? I've never heard of that before. Destiny, the thing with HIV is that there's no cure. It will stay in your body. The positive HIV 4th generation antibody test result indicates the presence of either three things. HIV1, I don't know why you're putting the same thing in here. Okay. I'm guessing this is just a form error, maybe. That's my guess. Actually, wait a second. How fast can they do these f***ing tests? Collected time, is that when they collected the sample? At 11:57 a.m.? And then they received time is when the lab, I'm guessing, so it was collected at 11:57. It was received by the lab like 14 minutes later. And then they had the results in 22 minutes and reported it to the patient? Is that normal? Can you do these tests that fast? I have no idea. It's minutes with the 4th gen test. Jesus. Well. Why do you, I don't understand why you guys are just typing the first thing that comes to your head and assuming either I'm retarded or the whole stream is retarded or that everyone is retarded. I've seen 4 people type this now. Positive appears in the normal column to indicate the expected result when the infection is present. Oh. So that means that he also has HCV and it means he also has HBV or whatever this is, and he also has syphilis because they all match the result in the normal? Is that what that means? Like, so he has everything. I think that this is just incorrect. I think the sheet was written wrong. Although I don't know why, because I imagine this is like a boilerplate sheet. They don't type this up uniquely every single time. The only explanation is that he tested positive before, so the expected normal result. I don't think you would ever change it to adapt per patient. I've never heard of that in my life. I think the normal column isn't really saying positive is healthy. It's just the laboratory's reference range / cutoff column. It's the expected value for a healthy human. That's what it's supposed to be for. So if you're getting tested for a disease, the expectation is you don't have the disease. So the normal range here is going to give you the expected result, the range of results you can get. So for HIV, I imagine your expectation would be negative on all these tests. I don't know. We'll see. I think it's a meme. That's my guess. But we'll see. Back to us. Could it be that he got PrEP to protect him from HIV? I believe that PrEP prevents you from actually acquiring the infection. It either helps your body create... Oh, well, does PrEP? I actually don't know how PrEP works. Does it help your body create the antibodies ahead of time? Or it does something so that the infection doesn't like take hold and you don't actually develop the infection. It kills it beforehand. I don't know how exactly, but...
Crowder says N-word on Piers Morgan show, starting at 7:45. Oh, this poor guy is brought in. Mark is brought in for so many white N-word sayers.
We are not.
Wait, what? Oh no. Do I want to watch this? I'm probably going to agree that it doesn't matter that much, and then it's going to look like I'm backing Steven Crowder.
Wanted to
Well, yeah,
get
but
to the point,
it is
but I agree with you.
complicated. It's complicated simply
Well, it's not that
because
complicated. It is
it's
anti-Semitic,
complicated
right?
because the actual lyrics, he would argue, are not anti-Semitic. He's trying to be clever,
Okay.
and I don't think we should give him the pass.
Okay, I agree. I'm trying to create a really, really blatant, obvious analogy here to make a point. So we both agree that it's anti-Semitic. I think it's bad. I think saying Hail Hitler is bad. Okay.
8:25.
That is, Hitler has enacted. That's a call to action. Defamation requires damages. And I want to get to this because this does make Hitler is bad. Okay. That is not, however, a violation in any way. Your First Amendment protects it. Now,
How can you be so forgiving of ex people but so petty and burn other people forever with others? I am like the least petty, most forgiving person in the universe. If you think I'm petty, here's the thing. This is a super easy test. If you ever think that I'm being petty about something, then the question should always be, why is Destiny being petty about this person? Because generally when you ask that question, you'll find out that that other person has been unfucking believably unhinged towards me, usually for a long time prior. It's pretty rare that I'm petty. And that's not even like because I'm a good person or I've thought about it. It's just personally, it's really hard for me to hold grudges. I'm like a very much in time kind of person. Like, even if I'm like, God, I hate this motherfucker, I'm gonna hate this motherfucker forever. Okay? Like, I'll go to sleep and I'll wake up and like 3 days later, be like, I don't care that much. And it'll be good content. Who cares? Fuck it. Like, this is like my general, this is my general disposition. You're super fucking petty when it comes to chatters though. Bro, the biggest fights I would usually get into with all of my mods and with RTBA was usually because I just say, listen, if a guy wants to ban, then unban him. Who cares? If you around, then ban him again. This was like the biggest fight I used to have with my mods. I don't know how you could possibly believe that, but... Fucking true, you are petty. You dump Sitch and Adam over your own drama at the time, but will go to bat for Dean, the white savior? What are you talking about? Adam and Sitch are the ones that stopped talking to me. They're the ones that ducked me. What? They, like, I'm pretty sure that Adam dude literally blacklisted me, and then they kept talking about me all the time. You want to talk about petty? Adam got so ass pain that there was a post on my subreddit or something where somebody said that they were MAGA, or maybe I said I felt like they just covered a little bit too much for MAGA. And then for the rest of the time I ever spoke about them, for months and months, I'd be like, I don't think they're like super MAGA. I just think they're probably further along on that center spectrum than I am, or they're a little bit more generous to MAGA. They're more generous to MAGA than I would be. I think they're too much on that. And they like lost their minds over it. And then their brain got broken on me for years, literally. Like, okay.
saying, I would like to, I am calling you to enact what Hitler has enacted. That's a call to action. Defamation requires damages. And I want to get to this because this does matter. Okay? When we're talking about this new song, and as a comedian and as a linguist, I'm going to say the word here so that everybody knows, and that's what you're going to clip. We're looking at words that are offensive, a song that is offensive, but one is a boogeyman word. We have one noun, a verb, and a noun. Okay, we have a noun by itself, contextually. That's bad. Shouldn't say it, but it's not imbued with any power outside of historical context. The last noun, Hitler, is imbued with the power of the verb that precedes it. Hail, to praise, to venerate. That'll get clipped, even though I'm condemning the song as anti-Semitic, and not one person here who would be the victim of a more severe call to action is going to say it's anti-Semitic. I think we're in a silly point in this country when we're pulling this clip to condemn the anti-Semitism here at the studio, and people going, hey, can I get a second cut of that N-word, Hail Hitler? That's the point. It's not genuine.
Would you have used the N-word in the way that you just did if you had a black guest with you?
Like Dr. Hill? Sure.
You would?
Sure. And here's the challenge again.
It's not a challenge.
This is the point. We're trying to use this as a tool. It's great for broadcast, but
God, don't make me do this. I don't give a f. I don't care. I don't care. I don't care. I just super don't give a f. Also, it's because I'm a gamer too, and we're just built different. Top 5 angry judge moments in court.
Because of those threats.
Oh, this is our Rittenhouse trial?
That means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting, with the defendant, to use his mere verbal threat on August 10th.
Ooh.
15 days prior that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial.
There's very particular rules about what type of character evidence can be admitted into court. Some judges are more strict than others. And Kyle Rittenhouse was in a car with a friend, and he said something about how, like, I wish I could shoot robbers or something like that. And the state wants this as character evidence to show that Kyle Rittenhouse is predisposed to violent action or something. And the judge thought that it was too prejudicial or whatever, or it wasn't valid. He said, this is not okay. Not okay character evidence. You can't do this. And then I don't know why, but the prosecutor for the state decides to just bring this up in the middle of the trial as part of his, I don't know if it was a line of questioning or whatever. And the judge has explicitly said, you can't bring this up. This was pre-trial. They already said you can't talk about this.
I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling because I made that more relevant. You would admit it, or at least consider it an admittance. I believe, based on the evidence that we've heard, and more specifically, exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial. And
That's like the worst argument ever. Now we're in the middle of trial, so I figured I could just like slip it in here and there's not fuck all you could do about it.
there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements do, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior, the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions, please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these.
What is propensity evidence? You're not allowed to like character assassinate somebody in most courts, I think, but in regards to the state of Wisconsin as well. You can't, like, let's say, for instance, let's say you're talking about harassing a witness or something, right? Let's say a guy gets accused of murder, okay? And then, like, even if you're, like, let's say that you've got, like, recordings or this guy's, like, a YouTuber and, you know, he's like, oh, God, I would kill to, I just want to kill these fucking Call of Duty players, or like, oh, I get so fucking mad sometimes I can fucking kill some of these people or whatever. You can't admit a ton of this evidence to court and say, like, look at all these statements he's made. Look at these, look at all of this evidence we have of his character. I think that he has the propensity to commit crimes because of, like, these statements that he's made. I think there can be highly specific statements, like if you say something that's, but it wouldn't be character evidence or propensity evidence or whatever. It would just be you. It would basically be you planning or talking about the crime itself. I think. Yeah. I think in general, I don't think you're allowed to admit this type of stuff unless it's to rebut character evidence that the defense offers of itself, I believe. The 90404 is the Wisconsin statutes and annotations. Chapter 904 has to do with evidence. Character evidence is not admissible to prove conduct. There are some exceptions, and then, yeah, okay.
Types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the crime. The prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Oof. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
Do we have the gentleman who did the videoing? Do we know?
He's will be available later, Your Honor. He said at the end of the day, and I'm trying to get him here by now.
Okay. What was the threat? Did Mr. Mummert know about this threat?
Mr. Mummert knew about the threat.
And what was it? You can move closer if you want, or that's fine.
May I approach you?
You can come inside the well about where Mr. Mummert's at. What was the threat? From who to whom?
In Mr. Mummert's office building, there was a gentleman who was evidently looking for a vantage point on the floor below Mr. Mummert at a place where there's kids in school, where they organize the kids to go to school.
My office is one floor above the Early Learning Coalition on Winkler. Go ahead.
Okay. They called the police on him. The police arrived. He said that, or when the woman he talked to, he told the woman that she wanted to know what he was doing. He says everybody will know in a couple of days. It's going to be all over the news. Evidently, it involved the building across the street as well. The sheriff's office, building across the street or across the parking lot, hired the sheriff's department to stay in the parking lot. I had a discussion with the sheriff. It was reported to the police. There was some concern. Actually, there was
who was it?
Chris Swanson? Gentleman's.
So what would that have to do with videoing random people leaving my courtroom?
Well, Your Honor, we frequently video in the lobby to see witness reactions and things like that. And
Not that I'm aware of. This is the first I've ever had it happen, and I've been a judge for 12 years. At least it's the first time it's been reported to me, and my staff's pretty good.
Videos in the lobby checking witness reactions. Wait, what?
Yeah. Many times, we're all putting a investigator out in the lobby, just like the state does with their investigators. They have them.
They don't videotape people.
No, they don't. And I understand the videotape.
Wait, what? This sounds wild. Dog, you're in court. You're in trial. Like all this shit should be. You're still investigating. What's going on here? Jesus.
Who's paying for this?
We are. I am. My office.
Mr. Mummert's not paying for it?
No. Anyway, Your Honor, the point was we weren't sure what.
Well, I mean, before you said it was a threat, now it's reactions from people. I mean, which is it?
Well, no. In this particular case, on the incident we're talking about, he was outside in the lobby with the TV cameras, and he was approached by one of the bailiffs and asked what he was doing there, and he said he was hired by me. The bailiff came to me and said he can't film there, and he said there was a court order, and I immediately shut it down and had him leave the building.
Well, it's general practice. I think there's actually signs that there's no video recording in this courthouse, period. It's not even my rule. It's a rule by the chief judge and for the whole building, which is why you have to get approval to videotape in here.
Well,
and which is why I expel people from my courtroom who do it. I'm be blunt. This has a feel to it of, I can't put my thumb on it, but I wouldn't say nefarious, but it just doesn't smell right.
And again, Your Honor, absolutely no disrespect intended for the court.
Are you the investigator for any of the other collateral cases involved with this one that are in the civil division?
No. No, Your Honor, it's nothing like that. With my sincere apologies, if I thought for a moment that we were breaking any of the rules, I would have not done.
You need him for anything else in this case? I think you should go.
Ooh, see ya.
But that other gentleman, I need to talk to him. Make sure he still gets here, but I think you should leave for the rest of the proceedings in this case and any of the co-defendants. Anything further, State? Mr. Mummer? Mr. Mummer, you can let me know when that gentleman's here, and I'll have a discussion with him as well. Thank you. For the record, Mr. Hunter's present, Mr. Mummert, and Mr. Sievers. Are you the gentleman who was filming outside of my courtroom? Yes, sir. Come on up. You stand over there by Mr. Mummer.
Oh, Jesus. Uh-oh.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter here today? Yes. You can put your hand down, sir. Please state your name for the record. Are you... Are you under the influence of any alcohol, narcotics, or drugs here today? No, sir. Have you ever been diagnosed with a mental disorder that would make it difficult for you to understand why you're here today?
I've been diagnosed with bipolar.
Are you taking medication for that?
Yes.
And why you're here today?
I've been diagnosed with bipolar.
Are you taking medication for that?
Yes.
Does it affect your ability to understand what we're talking about?
No, sir.
Sir, why were you filming outside of my courtroom?
I was hired by Mr. Olson.
And what specifically did he hire you to do?
He was worried about, he said there's a shady character he was concerned about, and he had me monitoring the lobby of the courtroom. And that's all I know. He's a friend of mine, so I decided to come out and help him out.
He give you the name of this person?
No, he didn't know the name of the guy. He was a tall gentleman, tall, skinny, elderly gentleman.
And did he, so he gave you a description?
Yes.
And did he point him out in my courtroom?
Not in the courtroom, but when we were in the lobby, he was out talking to me. He said that's the guy he was concerned about.
Well, I was under the impression you were filming more than one person coming out of my courtroom.
Well, he also told me, he said, well, I'm there to film reactions from the witnesses leaving as well.
For what purpose?
I don't know. I didn't ask.
Did you talk to Mr. Olson today downstairs?
When I came in, yeah.
I saw him down there. I think I told him to leave. Is there anything else going on in this courthouse? If he's not involved in that, he needs to leave the building. How much did he pay you?
That's still to be determined.
Okay. Have you done this kind of work for him before outside of a courtroom?
Not for him, no.
Okay.
Not for him. Base.
You can see why I'm concerned. It has a almost an air of witness intimidation about it.
I can see that.
You do understand that there are signs out front that say you're not allowed to videotape in this courthouse unless you have permission.
I was not aware of that, Your Honor.
Have a good day.
Thank you, sir.
Nothing from the state, correct?
Nothing from the state.
Defense?
Just, Your Honor, that this was not a request for recommendation of the defense.
Noted for the record. You've paid Mr. Olson for services in this case?
The JAC has paid Mr. Olson.
That's going to be scrutinized. Okay. Anything else from the state?
Judge, only because I heard the court's order, I exchanged pleasantries with Mr. Olson on the first floor as I was coming up just now. And so I'm just informing
I'm just
the court.
surprised he's here. I told him to leave this floor in this courtroom, and if there's no other business that he's here for, I'm a little befuddled by why he would be here.
He was on the phone. I said hi. He said hi back, and I got on the elevator.
Okay. Anything else from the defense?
No, Your Honor.
We're in standby again. We'll go off the record. Mr. Olson?
Yes, Your Honor.
Why were you having people taped outside of my courtroom the other day?
Oh, Jesus.
We were concerned about a threat that had been made a couple of days before Thanksgiving.
What would that have to do with taping people coming outside of my courtroom, including witnesses? You didn't have permission, did you?
I was not aware, Your Honor, that it was not permissible. There was some suspicious activity on that side over there. We were concerned. I just asked my guy to record who was coming out of the room.
How many people did you record?
I don't know, Your Honor. I have not seen the video.
Who's the gentleman who did it?
It is one of our technical guys.
He needs to be here by the end of the day. State's ready? Defense?
Yes, Your Honor.
You're unaware of any of this, correct?
Yes, Judge. None of this was my directions.
Okay. Bring him out.
Wait, what was the first one?
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me.
Other items, like a weapon, that could have also been removed from that crime scene, correct?
Correct.
You don't know the other.
You knew very well
that you told police in this case over the phone.
Investigator Johnson.
Wait a minute, don't interrupt her question, Mr. Skirt. Let her finish her question.
She's asking the same question over and over.
Be quiet.
No, she's.
Be quiet. Now. She asked you a question. You wait till she finishes.
I'm a grown man.
And then answer it, okay? Yeah. And she won't interrupt your answer either. Because the court reporter can't take down two people at once. Is that clear?
Yeah.
Sir?
Yeah, that's very clear.
All right.
Now, Detective Kirkle, as we talk about compromising a crime scene, now you can confirm your knowledge of a wallet being removed, correct?
Yes.
But you don't know if there was other items, like a weapon, that could have also been removed from that crime scene, correct?
Correct.
You don't know if the other item had been moved from one place and put in another place.
Objection, Your Honor. There is absolutely no evidence that anything was moved.
That's right. There's no evidence of that. Don't imply something, counsel, that there is no evidence of. None. There's been no evidence introduced in this case by any witness that is even close to that. That assumes facts, not in evidence. Sustained. Move on to a relevant question. Don't imply things that have not occurred and are not in evidence. Move on.
I'd like to now go to state 83, please, the during video.
And some people were swearing.
Absolutely.
And would you describe other people's demeanors as upset or angry?
I don't know if you've seen anybody be killed, but it's upsetting.
The answer is
yes. I was just going to object, Your Honor.
Argumentative, and then proceed. We are outside the hearing of the jury. Ms. Hanson, I'm advising you, do not argue with counsel, and specifically, do not argue with the court.
Is the cameras off? Are the cameras off?
No, they are not. We are on the record.
Okay.
You will not argue with the court. You will not argue with counsel.
Mm-hmm.
They have the right to ask questions. Your job is to answer them.
I was finishing my answer.
I will determine when your answer is done.
Okay, well.
And so, Do not argue with the court. Do not argue with counsel. Answer the questions. Do not volunteer information that is not requested. The attorneys for the state have redirect. They can ask you questions if they think that certain things were left out.
Okay.
It is counsel's prerogative to ask you leading questions and for you to answer those and not volunteer additional information.
Okay.
Are we clear on this?
We're clear.
Thank you. Come back tomorrow at 9:30.
All right.
You had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library.
Is the judge just kind of waiting for the objection so he can talk shit when he knows it's going on? I believe that I don't think a judge will typically interrupt unless somebody's really, really, really fucking up. It's usually on the defense or the plaintiff to object if they think something is improper, I believe. Okay. All right, can I go to sleep? Tina Peters. Wait, was she the she was.
Just put that in a record in front of all of these people that I believe something to be true.
Bro, this lady.
So when
She was the one that was sentenced to prison, she was convicted of, she let like some fucking Trump MAGA losers into some election office. She wasn't supposed to. She gave them access to voting systems that they weren't supposed to have access to. And she was convicted. The jury said she was guilty. And so this is her, she gets to address the judge before he sentences her. I believe it's the allocution. So she's basically just supposed to say like, hey, I think I made mistakes. I won't do this again. I'm sorry, whatever, bullshit like that. And instead she decides to take the opportunity to go on a whole ass fucking schizo ramble. And she brings a PowerPoint. She has a presentation for her schizo ramble.
if there was, probably none of these people have even read these reports that I gave them. So report number 3, when that ballot goes in to the tabulation machine, we've already proven it in report number 3. There's a second database that's created. So there's an image. So when they say...
This is not, the trial's over. She's already been convicted. The jury said she was guilty. This is just like, she's just having a total schizo ramble.
Well, we'll just count the images. Don't worry about the paper ballots. We'll just count the images. After ballots go in, there's a second fraudulent database that's created, and it's all documented in here. There's an image taken of that ballot, then the ballot is changed, and we know it's been changed because it's lacking the .sha file, and it goes through adjudication differently, like it's a completely different ballot. This is what report number 3 is. So when you ask, were there any fraudulent votes, they haven't read it, they don't know. All right, I'm going to move along.
Votes,
Sorry?
I'm not going to let you
go
on
fine.
about things that are completely irrelevant to the set.
This is irrelevant.
No, it's not. I've let you go on enough about this, but the votes are the votes. You still didn't answer the question. If this is my ballot and I put it in the machine, whatever it tabulates is whatever it tabulates.
No, it doesn't. It changes.
You're not letting me finish.
Okay,
whatever
please.
it tabulates is whatever it tabulates. My hand vote, my ballot remains the same. They counted those ballots. Did they not?
I understand what you're saying, Your Honor.
Did they count the ballots?
No, the ballot images were changed, and that's what the total shows. Okay, I'll move off of this because I can see that I would encourage to read the report number 3.
I've read them, ma'am.
You've read all of them?
I've read those reports. They were given to me at some point, I believe.
Good, good. Well, so you know what I'm saying is true. All right, let me move. Go on. It's not funny. My life is on the line here, Your Honor.
No, you're the one who's making this allegation that one,
It's not an
funny,
allegation.
and 2, that I know it's true. You're saying that as if I believe you, and I did not say that.
Okay.
That is why I made the sound, because it's insulting to me for you to just put that in a record in front of all of these people that I believe something to be true.
Okay, and I apologize for that, Your Honor. That wasn't my intent. I do apologize for that. It gets a little fiery when your life is on the line, and I apologize. But I told the candidates they didn't have anything to fear because they had brand new machines that they'd taken out. Rollins. Okay. This is my wrist. Yes, Main Street Bagels. This is a picture of my left wrist, which happened when the officer who arrested me on February 8th, 2022 made...
I will admonish that, as I've done it before for everyone.
Thank you. The doctor says because of all the stress, this is causing her the price. Because the DA was investigating, because they believed this stuff, that 700 above the full articles that the Daily Sentinel has put out to investigation. There was an attorney getting me ready for trial. And he says, Tina, I can't, and that's why I should have testified, probably, but...
Judge, I think is or isn't exculpatory. It's the defendant's job to make this Before I get into my comments, I'll enter judgment of conviction consistent
9
with the jury's
years.
verdicts as to counts 1, 2, 4, 6, 8, 9, and 10. As it relates to fines, fees, and costs, however, once they've chosen to exercise their right to go to trial. I consider deterrence in sentencing, that is, both general and specific, that the sentence I impose must deter Ms. Peters from engaging in similar conduct in the future, but it also must deter others generally from engaging in this type of conduct. I consider rehabilitation where appropriate. I consider punishment where appropriate. I also must ensure that the sentences I impose are consistent among offenders similarly situated, but I must also impose a sentence that is designed to meet Ms. Peters' unique needs. Here, the defense has, and Ms. Peters in particular, has remained quite defiant, which is her right, but certainly not helpful for her lot today. And in arguing why I should impose a particular sentence, she tells me about her ailments, her loss, her struggles in life. But in reality, for those of you who may have been here earlier this morning and seen some of the folks who've occupied that chair before Ms. Peters, there could be not much in the way of a comparison in terms of the type of sympathy one would extend to Ms. Peters. Those folks didn't have 4 lawyers representing them. They didn't have a team of assistants helping them. They're not getting rides in private jets all over the country. The people who sit in that chair suffer, generally speaking, immeasurable trauma in life, struggle mightily with alcohol abuse, substance abuse, mental health struggles, family loss. They come from broken homes. The cards they were dealt were never the cards that you were dealt, Ms. Peters. So when I hear you discuss your husband, who sadly passed away recently, your family struggles, and your son, who served our country admirably and made the ultimate sacrifice, I consider it. And I know, too, that he honored his oath to the country, something that is not lost on me when considering the circumstances under which you find yourself here. Your age, limited criminal history, and the like are certainly somewhat mitigating. Your ties to the community are what they are, but your reputation at this point is poor because of what you've done here and after. Your lies are well documented, and these convictions are serious. I'm convinced you would do it all over again if you could. You're as defiant as a defendant as this court has ever seen. You don't have those histories of drug and alcohol abuse. There's no lifetime of trauma, not even close to the type of mitigating circumstances I would see from many folks who sit in that chair. No, to the contrary, Ms. Peters, you are a privileged person. You are as privileged as they come. And you use that privilege to obtain power, a following, and fame. And to be sure, there's no doubt in my mind that is exactly what you wanted, and it defies all sense of common sense to believe when you suggested to me a few moments ago that you didn't want this attention. No, you crave it, ma'am. And there's no one in this courtroom who would consider that to be anything other than the absolute truth. But to get to the point of what it is that you did here, it's my impression distinctly that you never took your job of clerking particularly seriously. You didn't complete the certification. One scandal after another followed you in your time as the clerk. And ultimately, it was a belief that the echo chamber in which you live couldn't be wrong, among other things, that led you to do what you did here. This thought process, unfortunately, seems to consume so many in our country, regardless of race, gender, political affiliation, or the like, that what it is we hear and think can't possibly be wrong. There are many things in my mind that are crystal clear about this case. You are no hero, you abused your position, and you're a charlatan who used and is still using your prior position in office to peddle a snake oil that's been proven to be junk time and time again. In your world, it's all about you. But at bottom, this case was about your corrupt conduct and how no one is above the law. No one in this country has absolute power. Your position as a clerk and recorder, a constitutional position, does not provide you with a means by which to do your own investigation, to not listen to the judiciary, to not listen to the executives higher than you, to not listen to the legislature who sets the law as it may be. This is nonsense. Our system of government can't function when people in government think that somehow, some way, the power they've been given is absolute in all respects. And that's what...
Okay. She just gets arrested. Okay. I'm going to sleep. I'm tired. I love you. Drunk lawyer makes trial. Wait, what? Drunk lawyer.
Turn again.
I am advising my client to speak to...
Look, there's no question on the table. You are again speaking out of turn.
Contempt
You
number
want
4.
a fourth issue on this show cause order is getting longer and longer.
Your Honor.
Quit speaking out of turn.
Your Honor.
Shut your hole.
I have advised my client to take the Fifth
There's
Amendment.
no question on the table.
There have been many.
And he asserted his rights.
No, I have advised my client.
He did, and he did it 3 times. The first time, I saved him because you kept saying the wrong thing, and then he finally said the right thing to invoke the Fifth Amendment. Now,
She is
That is
right.
the fourth
Right.
contempt for speaking out of turn.
Curtis,
Mr. Coomer, you may
you are to
proceed.
take the Fifth Amendment immediately.
Your Honor, was Exhibit D8, the January 3rd, 2023 trustee's deed admitted into evidence?
Yes.
Okay, thank you, Your Honor.
No, that makes the competent ones more valuable.
Mr. Bueller, will you please put exhibit number D9, the temporary restraining order, up on the screen? And
Oh, here we go.
can you blow it up a little bit so everybody can see?
This is.
Can you slowly scroll down? This is the order granting application for a temporary restraining order.
This is
And then
worse
you
than
can
I even
scroll down. Keep scrolling down. We're looking for section 2A. Okay. Basically, if we can go up just a little bit, the court orders that Curtis Meeks and Ricky Henderson, as well as any of the
Curtis, you are to take the Fifth Amendment, your right to the United States Constitution, not answer one more question.
There's no
Miss
question on the
Miss
table.
Alexa, can I finish my question before you object?
Hold
No,
on.
you cannot.
What is
There's
happening?
a court order for section 2A. Okay. Basically, if we can go up just a little bit, the court orders that Curtis Meeks and Ricky Henderson, as well as any of the
Curtis, you are to take the Fifth Amendment, your
Wait, why does she keep saying this? Wait, why does she keep just randomly saying this?
right to the United States Constitution, not answer one more question.
There's no
Miss
question on the
Miss
table.
Alexa, can I finish my question before you object?
Hold
No,
on.
you cannot trample on his
Stop
constitutional
talking.
rights.
Stop talking.
Curtis,
I'm
take the
talking
Fifth
to
Amendment
you, Miss
immediately.
Alexa. Stop
Curtis,
talking.
end this now. Goodbye.
Wait, did she just leave?
Okay. Mr. Meeks, what I'm showing you is exhibit number D9, which is the temporary restraining order issued in this case on December 30th, 2023. Have you ever seen this document before?
Malpractice.
I plead the fifth.
Okay. And do you remember me showing
Okay.
you this document at the January 12th, 2023 hearing?
I'm gonna plead the fifth.
Okay.
Okay. And
She sure did.
if we can,
Rage
Let the
quit.
record reflect that Ms. Alexis has dropped off.
thank you, Your Honor. And can you,
I don't know what to do about that.
I've never seen it before, Your Honor, but this case is a lot of firsts for me, and it's confusing, but I just want to get through and do what we need to do.
You can't get through because you just.
But Mr. Meeks had a lawyer, although she, in my opinion, was not doing great.
No, she
Still,
wasn't.
he's entitled to a lawyer, and she made an appearance. How do we continue without her?
Brenda Walton and Walton Homes LLC last August and September.
Oh, you talking about Brenda? That I was. Oh yes, I didn't. I refused on that because I don't know her. I want.
Oh, that Brenda. That one. The one you were referring to the first time. Clearly.
I'm going there talking about it. But I don't know this lady.
Okay.
I went back.
But
Sorry.
you went ahead and had a mediation with Alan Guyton. Is that correct?
Yeah, we had a mediation with Alan.
Okay. On September,
Client. Yeah, Alan. We had a mediation with him.
Alan Guyton is now my client. He is represented by Rob Holcomb. Do you understand that?
That's your friend that you advised them to. Yes, I understand that.
Okay, so you mediated with Dean Kilgore and Rob Holcomb in this case, but you refused to mediate with me, Brenda Walton, and Walt Holmes, correct?
All right. Can we move on, please?
There was a question on the table. You can't just interrupt, Miss Alexia, the proceedings. You were not the judge. You weren't elected.
She's like, can we just go to the next thing? Wait, what?
To tell a witness to move along while there's a question on the table. I have thrice told you, please do not open your mouth unless you have an objection. And you again did it. So I'm upping your contempt.
Oh, no.
I'm going to issue a show cause order. You'll have an opportunity to argue why you shouldn't be held in contempt twice so far. 2 times. Answer the question. Do you remember it, Mr. Meeks, or do we need to read it back?
I need Kuma to re-say it.
I don't think I remember the whole question at this point.
Okay, Ms. Albrecht, would you please mind reading back the question?
Oh, sweet Jesus.
I'm scrolling.
Thank you.
Okay, question. So you mediated with Dean Kilgore and Rob Holcomb in this case, but you refused to mediate with me, Brenda Walton, and Walton Holmes, correct?
I don't recall their names, but I know Alan was there. So I don't recall their names while I mediated. And I don't know Brenda, so why should I mediate with her? I mean, we're talking about some money that I don't spend $900,000 on. Nobody's talking about that. Let's ask them questions. Well, Curtis, how much money did you spend? Or Brenda, how much money did you spend? Or Alan, how much money? I want to hear them type of question. Well, what is this?
Is this a criminal proceeding or what? Or is this a civil case or what is this? law offices and law firm, it would be a civil, right? Because it's not the state or whatever, right? What? But but he's not pleading the fifth in a civil case, right? What is happening? I don't even know what this is.
Clean, is it valid or not? Answer them questions, cool. So, like, give me to that. Like, did y'all spend any money? Yes or no? No. Did Curtis spend any money? Yes, no, yes. Like, let's hear that type of stuff. Because there's always a lien up there. It's a $250,000 lien, and nobody's saying anything.
Okay, it's on. This is on Jason here to tell this witness to shut up and answer the question, or object and say, Judge, please instruct the witness to answer the question. He just lets him run over him time and time again. He's good, but he's just not used to this sort of adverse witness, and it's actually fairly common. You got to have some game to deal with that.
Judge, nobody can move on that and say that lien was valid or not. Nobody don't want to get to those.
Okay, we're wasting court time. Can you please start earlier when you can see it's non-responsive? We're running out of time.
My will, Your Honor. My apologies.
We're going to have to get this done.
I will speed along, Your Honor. On September 30th, 2022, did Top and Ball LLC receive discovery in this case?
Your Honor, at this point, I am going to have to withdraw on this case. So
wait, Wait, what is this case? What is happening with this? I don't even know what this was over.
That's denied. Well, the case cannot proceed further.
You can't withdraw mid-testimony during a hearing. Oh, Lord.
Well, I mean, is that true? Is that a rule? Really? Is that actually, what if you die? Huh?
I didn't see this part. Holy. I can't even believe it. I mean, she's doing a horrible job. She'd actually be doing everyone a favor. You could request, but you would have to give some basis and request. And she just announces it to the judge as if the judge has no choice. Holy.
I declare my withdrawal.
Oh my God, here we go.
So I must proceed with a withdrawal. I do not feel that the judicial temperament has been fair toward my client.
Oh, good Lord. If you're withdrawing,
You're bullying my client, so I want to leave. I just want to get the fuck out of here.
You have some reason for doing that. If you're saying you don't like the rulings, you can appeal them. But I mean, this is just not good. This is just not good. You're sitting here.
Why? This is funny because Pixie's lawyers this came up with like the spoliation thing. Why, some people don't understand like forum. Like there's a time and a place to bring up certain objections, but some people are just like, I'm out. All right, I just want to leave. And it's like, if you feel like it really is unfair or whatever, fucking, you can appeal it. You can, I'm sure there's some fucking motion or some bullshit you could file to it, but you just be like, I actually just want to leave. I'm done, actually.
Here, insulting first of all, you have no basis to withdraw. It's too far along. You got to complete it. Secondly, you're now just stepping on the toes of someone who's clearly going to make the determination on this hearing right now, which doesn't matter much because you have a complete loser. Your client's full of it. That much is clear.
And I am not proceeding further. So that's it.
Bye.
Woman, you can ask me some more questions. I'm here to answer.
The judge is.
Wait, what did he say? Did he say you can ask me some more questions? Wait, hold on. Wait, what did he say?
Woman, you can ask me some more questions. I'm here to answer.
The judge is like, you can see her face. She went through all these things. She's like, that is so freaking stupid. I don't know where to begin. I mean, she's not saying it, but like that's the thought part. Like, I don't even know where to start with this. I've never seen anything so dumb. Okay, all right, let's see what she does.
I have Curtis. I have accurately and fairly represented you. I have invoked you to.
All right. Okay, I'm cutting you off.
Yeah,
Mr. Toomer, your next question, please.
Thank you.
I am, Your Honor. What I demonstrate or consider with your behavior is inappropriate.
Okay. Why are you saying this now?
With your behavior is inappropriate.
Okay, well, you can file something with judicial conduct or
I know,
whatever. And you are now being held in contempt for interrupting again for the third time. I've actually helped your client because you're not instructing him properly on how to invoke the Fifth Amendment. So actually, I've been fair to your client. You have been, I think he would be better off without you, frankly. So, but I am not excusing you. So don't.
I never made an appearance.
Okay.
Ooh, I have never seen that in over 25 years of practice. It makes sense, but I don't know, but I understand it. This is an extreme situation. I don't know, so I shouldn't be making. I'm not making accusations, but my guess is, by observing this, that this woman is altered. I think she's drunk. I think this attorney's drunk. She knows enough law that it makes me think that she is an attorney, but the way she's handling it is so bad. I don't think she's kind of like, I had a couple drinks. I think she's wasted. That's my guess. I could be wrong, but that is my impression as I watch this.
You did make an appearance. Okay. This is Mr. Comer, you may proceed.
Thank you, Your Honor. Prior to the foreclosure date of January 3rd, 2023, did you receive my application for a temporary restraining order?
Meanwhile, we got Steady Eddie over there, and he has no way. He's doing fine, but he's just chugging along in the most basic way possible. He has got no game to deal with this whatsoever.
Listen, he's just got questions to ask and a record to be written to. That's all he gives a f about. Okay, he's just here to get paid. Hell yeah.
He's doing fine, but he can't calibrate and adjust to it at all. It's funny.
I received your application, or just received an email from you?
Did you receive a copy of my application for a TRO before it was heard?
No, nobody. You mean the guy that came out to my house and tried to serve me? I saw him on the camera, and he tried to serve me, but I didn't get served at all.
Did you file?
Wait, are you allowed to dodge service? I actually don't know what the ruling is on that. Like, if you see the guy coming to serve you, are you allowed to avoid? Are you allowed to avoid legal service, USA? Sometimes the court can just rule on things and do shit without you even having okay. It's not, there's no, I guess you could delay maybe a court filing by a week or two, but
A response to my temporary restraining order.
Yeah, I responded to something because I sent your email.
Okay, how did you respond to my temporary restraining order if you never received?
I sent an email and it said something about TRO, and your other friend helped me out with Durwin McKee. Y'all all buddies.
Okay. So you did receive my application for a temporary restraining order, and you did file a response to that application. Is that correct?
Yes.
Okay. Were you personally served with the temporary restraining order on January 3rd, 2023?
Unbelievable.
what's unbelievable about that? She's like, didn't you hear my client just say that he saw them coming on the camera and he dodged them?
So you don't get to belt out unbelievable after the opposing counsel posed a question on their examination. If you think it's unbelievable because it's inappropriate or wrong, you say objection and state the basis for it. If not, you shut your hole. That's how this works.
That will be a fourth contempt for another interruption.
Oh, I'm sorry, Your Honor. I thought that it was muted.
Okay, I'll take that one.
Oh my God! And then she took it back. See, there we go. She show cause. Okay, and she won that one.
One off then.
Oh, bullshit.
Holy shit.
No way. And the judge doesn't believe it either, but she's trying to placate her a little bit. She literally just wants to get through the freaking hearing, which is appropriate. That's all the judge is trying to do.
You're still at 3. You may proceed.
Thank you, Your Honor. Were you personally served with a temporary restraining order on January 3rd, 2023?
That could be the case.
Okay.
I think
Mr. Bueller, would you put Exhibit D11, Meek's temporary restraining order, up on the screen?
That's possible.
Do you see where the citation states that you were served with the TRO writ on the 3rd day of January 2023 at 9:50?
Oh, you talking about the TRO for the foreclosure deal, where I loaned out some money, the same thing as Park Place Funding did, and I didn't get paid, and I actually foreclosed. So you talking about that TRO?
Objection, non-responsive. Instruct the witness to answer the question. That's how this is done.
I'm talking
Park Place Funding did the exact same thing that I did. Like Park Place Funding did it. I'm doing the exact same thing Park Place Funding did, because we are Monday members.
Oh, I'm going to lose
But
my
I get retained on it, though, right? Like, I get in trouble because I wanted to foreclose. That's what you're talking about, the TRO? Oh, yeah, I see it. Yeah, I see it.
Is he saying that Curtis's attorney should object non-responsive? Can they do that? Or is he saying the other attorney should? Because for the other attorney, is it in their interest for the Curtis guy to just yap? Because if he's just yapping and he says dumb shit, that can only hurt him, no? Like, he can't help himself, can he? I don't know.
Right, like I get in trouble because I wanted to foreclose. That's what you're talking about, the TRO? Oh, yeah, I see it. Yeah, I see it.
Your Honor, what would you like me to do in this position?
Is she not like, is she a lawyer? Does she not know? She's like, I don't know what my options are right now. So I've done I've done the Phoenix Wright game, and usually like a menu would have popped up by now, but I don't know what you want me to do.
Shut your hole.
You just need to sit there and be quiet. She said we got to be quiet. And they come and talk.
Wait, what?
You just need to sit there and be quiet. She said we got to be quiet. And they come and
Is he telling his attorney to shut up?
talk.
Her client even agrees with me.
Oh, man.
Unless you have an objection under the rules of evidence or procedure, statute, case law, or constitution. One of the two to govern us.
I like you, y'all. You're a nice lady.
Well, thank you very much.
When your client sucks up to the judge after he smacks you down, that's not good. I don't think I've ever seen that ever in my life.
All right. So I will say nothing and not represent my client.
They come and just let them ask me the questions.
Your Honor, may I proceed with my questions?
Yeah. Did you offer D11?
I haven't yet. I'm getting ready to. I'm just trying to get Mr. Meeks to tell me if he sees the citation that states he was served on January 3rd, 2023 at 9:50 a.m.
The judge could ask if she's altered. Generally speaking, you would try to do that privately on a break or something like that if you really have those concerns. The judge could go that direction, and that may actually happen. But I think we're on Zoom, so it's hard to ascertain, and it makes it very difficult.
I wasn't served, but I see the paper that you got right there.
Okay. Do you remember being personally served by a Travis County constable with this TRO, temporary restraining order application, and TRO on January 3rd, 2023 at 9:50?
The one that he signed? Is he saying he doesn't recognize it?
I just told you I wasn't served. How many times you gonna keep asking me? I said, explain. I wasn't served.
Were you served with any paperwork on January 3rd, 2023 at 9:50 a.m.?
I wasn't served. You probably had my agent was served, Ricky Henderson. He probably was served. I wasn't served.
So you received no papers from any constable on January 3rd, 2023?
No. Because don't they have cameras on their body where they can see you? Doesn't run them cameras back.
I have a citation returned by the constable that states that you were served on January 3rd, 2023 at 9:50 a.m.
Well, that's not a question. Move along. Next question.
Okay.
Thanks, Greg.
Did I show you this same citation at the hearing on January 11th, 2023?
What you say? Say it again.
Okay. Did I show you a copy of this same writ of TRO and citation at our hearing on January 12th, 2023?
You said that you showed me?
Yes.
No, you didn't show me anything.
Did you attend a hearing on January 12th, 2023?
Yes, and then that's why we're here today. We scheduled it for today.
Exactly. And during that hearing, you remember me showing you a PowerPoint presentation?
A PowerPoint?
Yes, a PowerPoint presentation like I did earlier, where I went over the documents in this case, and I explained how you violated the TRO, and I showed how you were personally served with the TRO. Do you remember that?
I mean, you showed a lot of papers to me, but I don't be understanding what it is you're trying to get to. You just trying to say you're trying to take my money? You want me to give all my money to you? You and your client is Brendan Allen?
No, all he really wanted you to do was sign a special warranty deed, putting the property back where it was supposed to be. That's what he wanted. He gave you a lot of opportunities to do that.
Well, I wasn't doing it. I'm not listening to him because it's not his property. We're going to court for a lien, $250,000 lien.
And good luck to you.
I'm not right. I hope the luck do change. I hope it changes. I'll be glad when you rule on it. I want a judge to rule and say, Curtis, you lost. All the money belongs to Coomer and Allen and Miss Brenda, and that's it. And I'll be happy with that. I'll be done. I don't have nothing else to say. So we'll be over with.
Exactly. Do you understand that I told you today and I told you on January 12th in both hearings hold on, let me finish my question, that you violated the temporary restraining order in this case?
I didn't violate nothing. That's the same situation that Park Place Funding. If I violate something, Park Place Funding violated something. I didn't violate nothing.
Have you ever reviewed the temporary restraining order in this case?
I reviewed it.
Okay.
After the fact.
Do you understand that the temporary restraining order prevented you from encumbering this property, that it prevented you from transferring this property, it prevented you from foreclosing on this property, but you did that anyway?
No, the lawyer told me that the TRO wasn't active yet. So it wouldn't stop me from foreclosing on the property. It just said the TRO is coming, but it wasn't active at the time. So the lawyers, I'm hiring all these lawyers and paying them, and they tell me what to do, but it looked like all the lawyers just tell me wrong.
And that could be, Mr. Meeks, but just so we're clear, you were aware of the TRO before you transferred the property, the Denfield property, on January 3rd, 2023. Is that correct?
It gets worse.
Objection.
Was I aware of it?
Yes.
Objection.
What's your objection?
It's asked and answered, and it also assumes facts not in evidence.
Overruled and overruled.
Yeah. No, Kuma.
Well, you just said you consulted an attorney regarding the TRO. You had the Denfield property transfer.
Wait and see.
So how did you consult an attorney regarding the TRO and then have the property transferred?
An objection to counsel testifying. Facts are not admitted in evidence, Your Honor.
Can you rephrase that, please? And are you still going to use this service, or did you offer it? Is this D11?
Yes, Your Honor.
It's hard for me to see the witnesses, and I'm supposed to be evaluating the credibility of the witnesses, and it's taking up a lot of space.
Okay, thank you, Your Honor. We offer Defendant's Exhibit D11, the Meeks temporary restraining order writ into evidence.
Any objection?
Absolute objection. It is a forgery.
Absolute objection.
Bro, that's when shit is real. When you get to the absolute objections, this is a forged document. Are they like in trial? Is it like a bench trial? Is this a trial? Or are they just doing like a hearing right now? Well, no, she's like objecting, and I guess this is the trial. It's a bench trial, and that's why the judge says she needs to see the witnesses. Okay.
That's the dumbest crap I've ever heard. That's an absolute objection. Oh, she may have an affidavit of truth that she can file in support of her absolute objection.
Overruled. D11 is admitted.
Okay. Now, Mr. Meeks,
This whole thing is awkward. First of all, I keep beating up on him. He knows his stuff. He knows his case. The lawyer who's got him on, but he's not a litigator. He's a transactional attorney. I figured out what's going on here. So he's okay. He's going through the case and sort of doing it in workmanlike fashion, but he's not used to day in, day out getting lied to like me. So I after years of this, you learn how to redirect these things a little bit better. But that's my theory. So he's just sort of awkward and out of place in a hearing. Not horrible, but just not good at it. And she's insane. Well, I don't know. Altered or just not here today. I don't know. And this guy's completely full of it. Oh, the judge is losing her mind.
you testified that you spoke to a lawyer regarding the TRO, and then you went ahead and transferred the property. Is that correct?
Objection to Defendant Foundation.
Overruled.
Damn.
Which lawyer, counsel, if you would rephrase, please?
He could
Any lawyer.
He wants to proceed.
Which lawyer? It counts.
You're speaking out of turn again. You're being warned.
If you would rephrase.
What was the question?
No,
the question is, Mr. Meeks, you testified that you consulted a lawyer about the TRO, and then you transferred the Denfield property because you thought it was okay. So my question is, were you aware of the TRO before you transferred the property?
Yes, just on that day when it got foreclosed on.
Okay, thank you. Mr. Bueller, could you please show Exhibit D8, the January 3rd, 2023 trustee?
I just got disconnected.
We can still hear you. Mr. Meeks?
Hi there.
Mr. Meeks?
I just got disconnected.
Mr. Meeks, can you, do you recognize Exhibit D8, the January 3rd, 2023 trustee's deed?
Yes.
Jesus.
Okay. And do you see on page 1 where it says the trustee's deed and the date January 3rd, 2023?
I see it.
Okay. Do you also see the address and the description of the Denfield property on the bottom of page 1?
You say what?
I say on the bottom of page 1, it says property address, and it says 1132 Denfield Street, Austin, Texas, Austin, Travis County, Texas, 78721. Is that correct?
Yes, property I own. Correct.
Okay, so this trustee's deed is for the Denfield property. Is that correct?
Yes.
Okay. Do you see Top and Ball Properties, LLC, listed as the purchaser guarantee in this document? A grantee, purchaser grantee.
I see everything that you're telling me, Coleman. Like, what is your question? What you trying to know?
I'm just trying to make sure you're familiar with this deed. You have personal
keep asking me,
knowledge.
do I see it, brother? I see everything right in what you're saying.
You asked me, do I see it, brother? Oh, it keeps getting better.
Okay, so you agree with me that this trustee deed has Top and Ball Properties?
I don't agree with you with anything. I didn't say I agree with you. I said I see it. I don't agree with you with anything that you said. I don't agree with you with nothing.
Okay.
Because you don't have no money involved. You're just trying to scheme and get money out of somebody. That's what you're trying to do. But I just want the judge to go ahead and rule on the situation so we can be through with it.
Okay, Mr. Meeks.
I want to go give me a life sentence. Say, hey, Curtis, you get a life sentence. Rule that.
Mr. Meeks, who is listed as the purchaser grantee on this document? Is it Top and Ball Properties, LLC?
You say, is it Top and Ball Property? You say the grantee, the owner?
Yes, the purchase
He
of
doesn't
grantee.
understand any of these things. He literally
Okay,
doesn't.
Talk about property LLC.
Let's move to page 2 of Exhibit D8. Do you see the time of the sale as 11:07 a.m.? Is that correct?
You say what?
It says that the sale time is 11:07 a.m. and the sale date is January 3rd, 2023. Is that correct?
That's what it says on this paper right there.
Okay. And do you agree that this was less than 2 hours from the time that you were served with the TRO?
It sure does.
I wasn't served, so I don't know what you're talking about at that time.
Okay. It's less than 2 hours from 9:50 a.m. on January 3rd, 2023. Is that correct?
Objection asked and answered.
Overruled.
Mr. Meeks, do you also see in this trustee's deed marked as Exhibit D8 where it says Curtis Meeks, mortgagee, directed Ricky Henderson, trustee, to administer the trust provisions?
Objection. I advise you to take the Fifth Amendment, Curtis.
Oh, this is when she starts to crash out.
Objection asked and
Sale as 11:07 a.m.
So I don't know what you're talking about at that time.
Okay, it's less than 2 hours from 9:50 a.m. Curtis Meeks, mortgage.
Yeah, I see that.
Is this statement in the deed correct? Did you direct Ricky Henderson to default on a deed of trust and to administer the trustee provisions?
And it still gets worse.
Objection. Objection. I advise you to take the Fifth Amendment, Curtis.
Is that an objection? Is that grounds to object to something? Does it tell someone to stop answering questions in court? Can you do that?
Where we at with it now, Coleman?
Either you're going to take the Fifth Amendment.
Where we at with it now, Coleman?
Either you're going to take the Fifth Amendment or you're going to answer my question.
I advise you to take the Fifth Amendment.
Okay,
Curtis.
he's asserted his right. Next question, please.
Okay.
Can you? I thought if you agree to take the stand, don't you not revoke your right? Don't you forfeit your right to take the Fifth? Although this is a civil case, I have no idea what's going on in any of this. I don't even know. I don't know if you're allowed to retake it or whatever. But maybe since this is civil, maybe it doesn't matter, or maybe you can. And I just.
You understand by directing Ricky Henderson to default on the deed of trust, he was enforcing the deed of trust against the TRO and violating the TRO.
And take the Fifth Amendment again. Curtis, you're to take the Fifth Amendment again. Invoke your right.
Take the Fifth Amendment.
Your Honor, I ask to admit Exhibit D8, the January 3rd, 2023 trustee's deed into evidence.
How would you even assert the Fifth if you're not testifying? Well, generally you don't. In a criminal case, if you're not taking affirmative defense, you just don't testify against yourself. I thought that if you do agree to testify, though, like if you say like I agree, I'm going to call myself to the stand or whatever, and then the state comes to cross-examine you, you can't just plead the Fifth at that point. No, you absolutely can't. There's no way. Like if I decide that I want to go up and I'm going to testify in my case and I'm going to give testimony or whatever, and then the state comes to cross-examine me, and then I say, actually, I'm pleading the Fifth on I did all my testimony, but now I'm not going to answer any of your questions. There's no way you could do that, right?
Any objection?
All objections. Curtis Meeks has invoked his Fifth Amendment.
Okay, he is offering.
All objections. I've been doing this a long time. I've never, ever, ever heard an attorney, a pro say, anybody say all objections in response to any objection. Never once. This is the first time. Oh, that is delicious.
Defendant's Exhibit A, that trustee's deed executed, I believe, January 3rd, 2023, if I read it down correctly. Do you have an objection to the admission of that?
I have objections to everything. My client is now advised to take the Fifth Amendment.
Overruled. Okay.
Well, you don't get to overrule him.
I object to.
Move forward. My client is.
Wait, did the client object too? I'm trying to keep score here. I'm trying to. It's like, it's like, it's too much.
Taking the Fifth Amendment.
Right.
No,
Miss
not
Alexa,
one more.
you want to do number 4? You are speaking out of turn again.
I am advising my client to speak to.
Look, there's no question on the table. You are again speaking.
Jesus. Sorry, hold on. I'm just curious about this. No, well. I'll look this up tomorrow. Okay, I'm going to bed. I don't know why we stayed up so late. Oh, I ordered stuff on Amazon, that's why. Okay, I love you. I'll be back. Be careful. Don't die.